excited. We're ready to go. I'm Tom Martin from the law firm of Goldblatt, Martin Posen. We are working with Think Local First DC in a series of seminars on upcoming laws that are going to be particularly impactful for DC business owners. And today we've got a lot for you. I was just joking with Billy Martin of Billy Martin's Tavern in Georgetown. If you haven't been there, it's great. You should go. Free advertising there. We got some expensive new things coming down the pike on July 1, 2019. So we want to give you as much heads up today as we can. Today our presenters are the associate attorneys from our law firm. We've got Mr. Hilgers, Ms. Yontop, and Mr. Facci. They're going to be telling you about what is coming our way. Couple things, since we've got a packed house, I welcome all of our presenters, welcome questions, enthusiastic or not, war stories, good or bad. And then sort of just to start off, I think it would be helpful if we could start in the back corner and go around with just a brief intro, name, and the company that you're from, and we can snake around this way and just find out who all's here with us this morning.
I'm Vanessa Wen, and I work for the Ford Agency in DC. Here. I'm Chris Silverman. I work for H2 Collective.
Hi, I'm Vaishali, and I work for H2 Collective.
Parker Roach, downtown Open District.
Hallie Clem, Tenley Town Trash.
Sarah McCarty, Timber Pizza, and Call Your Mother.
Sarah Valpova for 2 Amy's and Art Show.
Clementine Thomas, JWC.
Joel Tyler, Tail Up Goat.
Felipe Quesada with RUIC.
I'm Chris Miles, also with RUIC.
Harmony Dale with 3 Stars Brewing Company.
Mari Rodella with DC Brow Brewing Company.
Ashley Howe, also with DC Brow Brewing Company.
Bridget O'Keefe, IMP, the 930 Club fan.
And Harold with Justice and Sustainability Associates.
Billy Martin with Martin's Tavern.
Earl Snyder with Martin's Tavern.
Luis Valle with Martin's Tavern.
Excellent. Great group. I'm looking forward to a wonderful discussion here today. We're going to learn a lot. And without further ado, I will turn the floor over.
Hi, everyone. I am taking you first. So the natural progression of this presentation, I am taking you through your employee classifications in the sense of, are the people who are working for you independent contractors, employees, or are they interns? After that, Mr. Facci will follow with actual employee classifications, exempt, non-exempt, how you pay overtime, who gets overtime, and then Mr. Hilgers will take us through the Unpaid Leave Act, which is coming up soon, or the Paid Leave Act, which is coming up really soon. All right, so to start, we don't have the presentation up on the projector, unfortunately. We can't get that to work, but you all do have the presentations in front of you, so feel free to follow along. Also feel free to interrupt with questions. We always enjoy hypotheticals, or if you have a live scenario, we can help walk through that as a group so we can all learn and apply the things that we're going to be teaching you today. So first up, in terms of interns, independent contractors, and employees, these things are constantly changing. As recently as January of this year, the test to determine whether or not you have employees or independent contractors has been altered. So this is a constantly changing thing. The last time it changed was in 2015. Before that, it was 30 years. And different agencies have different interpretations and tests for determining who an employee is. So why does it matter? It matters because it affects employer liability. It affects the kind of work that you would have the individual worker do. You know, an employee is going to be performing different work from an independent contractor, which will be different work from an intern. It affects how workers are paid. As you know, employees, they fill out a W-4, you withhold taxes, you have to pay Social Security, you have to pay unemployment. Independent contractors don't have to be paid these things and don't have to have these withheld from their pay. And interns can sometimes be unpaid. So that's why these classifications are extremely important to understand and to make sure that you as businesses are protecting yourselves from any unintentional liability. And we'll walk through each of these one by one. So first, who is an intern? These slides contain various tests, so keep them. They are yours to do with as you please. These lists are helpful in identifying who is who in the workplace. For interns, we use a 7-factor test, and I can walk through each of these factors. First, do both the intern and the principal being the business, clearly understand the nature of the relationship and that it's not meant to be an employer-employee relationship. This is extremely important. The understanding of the parties is very important in determining what your employment relationship will or will not be. So that is the first factor for any kind of working relationship that you have. The second factor is, does the internship provide training similar to training given in an educational environment? Interns are not employees. They're not meant to be representing your business. They're not meant to be doing the tasks that should be fulfilled by an employee. They're meant to be there for educational purposes most of the time, which is how you can have them do tasks without paying them. Because in a sense, they are receiving some kind of benefit, the benefit being academic or educational benefits from working in the work setting. The third factor is the internship tied to the intern's formal education program by integrated coursework and the receipt of academic credit. This ties into that second factor. Is this part of an academic program? Is the individual learning from the business? Are they growing in a way that maybe it's kind of a pre-employment training, preparing them to enter into the work field? This is the purpose of an internship. The fourth factor is, does the internship accommodate the intern's academic commitments by corresponding to the academic calendar? This factor is not dispositive, meaning if it corresponds with the academic calendar, a judge isn't going to look at that and say, oh, it follows the academic calendar, that means it's an intern. That's not what this means, but it is a factor. It's an indicator that the intern is doing this for academic reasons. So this is helpful. Usually we'll see internships try to track, a summer internship or a semester internship. That is extremely helpful. Make sure that that is tracked. The fifth factor is the internship's duration limited to the period in which it provides the intern with beneficial learning? Again, this ties into the academic setting. Is it tied to a class? Is it tied to a seminar where for the duration of the, for the duration of the internship, are they actually learning something? Are they talking it through with a professor or a mentor to understand how this can be applied to their future work lives? The sixth factor is, does the intern's work complement rather than displace the work of paid employees while providing significant educational benefits to the intern? This is going to be one of your most important factors. The reason is, back in the early 2010s, there was a case where interns, a very famous case, where 2 interns sued Foxlight Search Productions in New York City. It was a case out of the Southern District of New York, and there were interns who claimed that they were doing the work of employees on the set of the Black Swan movie back in 2010. The court there sided with the interns, saying the work that you were doing could have been done by any employee, or could have been done by any employee. So they sided with the interns and said, you are owed pay for the work that you did. This was an unpaid internship. It was very embarrassing for the company. And so this factor is going to be one of your most important factors in deciding who is an intern and who is not an intern. And then the final factor, do the intern and the employer understand that there is no entitlement to a paid job at the internship's conclusion? And this kind of ties into, as I'm sure a lot of you know, that probationary period that some companies implement at the beginning of a hiring. Some companies will say, we'll hire you and give you a 90-day probationary period, at the end of which you may continue your employment, but this is just so you can get to familiarize yourself with the working environment. Internships are finite. There is no promise of being able to stay on after the period ends. There is no guarantee saying you may be able to keep your job. It's not a job. It's a discrete internship that is tied to an academic program. So this one, I have seen a lot of problems with confusing interns with employees. You know, a lot of people say, oh, internships, it's cheap labor, we're helping students out, but we're also getting them to do some of the work that we can't afford to pay an employee for. That's some rocky terrain, and there is actual case law out there saying that interns are complete separate entities or individuals from employees. So be careful for that one. Does anyone have any questions or any examples that they want to walk through at all about interns? No? Okay. So the next test, the real bulk of what we're going to be talking about today when I'm with you is the difference between employees and independent contractors. This is probably one of the issues that we run up against the most when it comes to employers and their liability and how they pay their workers. So I'm going to walk us through the older test. You have 3 different kinds. The Department of Labor has issued multi-factor tests. You have the one that was just released by the National Labor Relations Board in January, is the more updated test. And the third one is the IRS has a list of factors that they go through to determine whether or not you are properly withholding taxes. Hi, just find a seat wherever you can. So the first test is what we call the economic realities tests. This is the test that if you go on the Department of Labor's website, this list is still up there. They still recommend that people follow this list. I caveat that, saying we should always follow what the courts say in this matter, or if there's a statute that explicitly says what the factors are. There is no statute that tells us what factors we need to use. So we follow court law. But Department of Labor guidance is very important. It's informative, so let's walk through this. The factors of the economic realities test is, first, the type of relationship that the parties are creating. This sounds a little similar to the interns. The second one is if the work performed is an integral part of the employer's business. And that basically tells you that independent contractors will usually be on for discrete projects. They have their own business aside from what you as companies have. They come on to help you with projects because they have expertise in a specific field. And you might not be their only client. You might be one of 100 clients. That's going to be an integral difference between an employee relationship and an independent contractor relationship. The third factor is the worker's managerial skill and whether that affects the worker's opportunity for profit or loss. Again, this ties into whether you employ them and you're the only one that they can work for, or if they're an independent contractor. If they have 20 other clients, their opportunity for profits and losses aren't tied to your business. They have other opportunities elsewhere and they're not tied down strictly to how your own business operates and your own profits and losses. The fourth one, if the worker is retained on a permanent or indefinite basis, we've talked about this one. Most of the time independent contractors are going to be discrete projects. The fifth one, if the worker's investment is relatively minor compared to the employer's investment, oftentimes you'll see independent contractors have their own equipment, their own employees even, and those are going to be separate from your investments, from your facilities, from your employees. They're 2 completely separate things. Number 6 is if the worker exercises business skill, judgment, and initiative in the work performed. Who sets the work? Who sets the schedule? Who sets the pay scale? Is it you or is it the independent contractor? Independent contractors will often have their own pay scale for their own employees. They'll say, okay, we'll show up when we can show up. They're not tied to whatever your business hours are. And then finally, if the worker has control over meaningful aspects of the work performed, who is dictating their job? Is it them themselves or is it you as the business? This is the we call it the economic realities tests because it is heavily based on the economics of the working relationship. Now, the courts have been steering slightly away from this, saying that the economic realities test is too strict of a test and makes it too easy for people to be found to be independent contractors. partially because there are two more considerations, which are on the next slide. These two other considerations, we've discussed this a little bit, they tie into some of the other factors. Is there a realistic ability for the independent contractor or employee to work for other companies? Independent contractors will have a realistic opportunity to work for other companies. Is there a proprietary interest in his or her work? This is where we get into, is it a work made for hire? Is all of their work product, does that belong to you or does that belong to them? So this is how we determine, who is an employee, who's an independent contractor. So that's the economic realities test. That's the Department of Labor test. On the next slide, we go into the recent update from as recently as January 25th, 2019. There was an NLRB, a National Labor Relations Board case called Super Shuttle DFW Inc., where the board looked at this you guys are familiar with Super Shuttle. They're the blue shuttle that goes out to Dulles or BWI. And the way that company works, it has a parent company and then it has a bunch of franchisees and the one franchisor. So the question there was, are these franchisees independent contractors or are they employees of the parent franchisor? The answer there was they're independent contractors, partially because they rent out their own vehicles, they pay their own employees separately, they determine what their employees' schedules are, what their pay rates are. But this has been a question that has come up at the NLRB again and again and again. This was something that had just been decided as recently as 2015 with the Browning versus Ferris case in the Court of Appeals. So this is a constantly changing test, and we are trying to stay on top of it as best as we can. So if you ever have any questions, it is always good to consult your attorney or an HR expert, just to make sure that you know the latest in what the trend is. So this multi-factor test is actually reduced from the Department of Labor test. It has 6 factors instead of the full list of 9 factors. It doesn't rely as heavily on economic realities because they understand that money isn't going to be the only thing that determines who is an employee and who is an independent contractor. So these criteria are similar. I don't think we need to go through them one by one just because they are so similar, but you have the 2 lists. Star this list, highlight it in rainbow colors. This is the test that you will be using to determine whether or not you have an employee or an independent contractor, because this is what the National Labor Relations Board has issued as its latest decision, and this is law. And that takes us to business liability, which is does anyone have any questions about any of the tests? Okay, great. That takes us to the why does this even matter? Why go through the headache of looking at all of our workers to determine, is this an independent contractor, is this an intern, or is this an employee? Business liability. 90% of why employers have lawyers is to avoid business liability. And the classification of your workers is important because depending on the classification, you may be liable for their actions. This first slide here is a list of all the statutes that are not all the statutes, of a big number of the statutes that are affected by these classifications. The tax code. Whether somebody is an independent contractor or an employee determines how their taxes are being paid. Are they paying it themselves, or is the employer withholding money so that they can have their taxes paid for them? Vicarious liability, we will get into this. This is the law that tells the world, this person works for an employer. The actions of this person can make that employer liable for tort negligence cases. So we're going to walk through that. Workers' compensation, independent contractors don't get to claim workers' compensation if they are not your employee. These are specific to employees, Fair Labor Standards Act. They govern employees, not independent contractors. That's your minimum wage law, your overtime law. That's why this is important. So the issue of vicarious liability. If an employer gets into trouble because of something their employee did, it is most of the time going to be a vicarious liability issue. Was that person representing or acting on behalf of the business Was that person authorized to do the thing that got them into trouble in the first place? And your classic case is, there are many cases, but your classic case is going to be, let's say you have a business that has drivers. And that driver, while en route to do a delivery, gets into a car accident. Who is liable for that car accident? Well, if the employee did that while en route to doing a job for the employer might be liable. And there are very fine exceptions to that. You know, you have your frolic and detour. If they were going and stopping for lunch or getting coffee or meeting a friend, all of a sudden they're outside of the employer's world of business. So maybe the employer isn't liable. But by the fact that that person is an employee of the business conducting business for the employer, you have vicarious liability and you have a bit of a problem. So this slide gives you a little bit of information here. A bright note, I guess, is that you don't get vicarious liability. Oftentimes you don't get vicarious liability for intentionally wrongful acts or acts that require criminal intent. There are exceptions. This might be relevant for something like the 930 Club if you have a bouncer. That might be a slight exception, but otherwise in general, vicarious liability will attach to an employee. Now, if the person is an independent contractor, it's a different story because they were acting on their own. They chose to take that route. They chose to do their own time. They chose to use their own vehicle. All of a sudden, vicarious liability isn't as applicable because the independent contractor is basically somebody who determined how they would do things. So that's one of the reasons, one of the big reasons why the classification is important. Does anyone have any questions on vicarious liability? All right. Civil rights statutes. I've talked about this a little bit. Civil rights statute, the list here, only applies to employees. Not only does it apply to employees, but determining your worker status also determines if you as an employer are liable under these statutes. For example, the DC Family and Medical Leave Act only applies to employers with 20 or more employees, not workers or staff, employees, full-time employees. So you need to properly classify your workforce to even see if that statute applies. If it doesn't apply, you are not subject to the requirements under that statute. So this is another reason why it's really important to determine that to properly classify your independent contractors and employees. The Age Discrimination in Employment Act, we see this one come up a lot. It only applies to employees. If your worker is not an employee, they are not protected under this statute. An independent contractor is not protected under this statute. So these are all very important things to remember. Does anyone have any questions about this? Okay, great. So this next slide is something that does come up. You know, once you determine who's an independent contractor, who's an employee, you still have the issue of joint liability. This is a topic that could be covered in an entirely different presentation, but it is important to bring up now because just because, let's go back to the Super Shuttle case. Super Shuttle, you have franchisor, franchisee. One of the problems we do run into with franchisors and franchisees is the joint employer relationship. Yes, the franchisee, the smaller company, the one that's probably run by a mom and pop shop, they might be independent contractors. The next step to see if there's any shared liability is to determine if they are joint employers. So it's a slightly more complicated issue. These are the list of factors that you look at to determine if you are a joint employer in a situation. You have this. If you have any questions, feel free to come up and ask. But one of the more dispositive factors in this list is, do the potential joint employers share supervisory authority over the employee? That's going to be one of your really big factors there. Are you and the head of the independent contracting agency sharing in how you're monitoring the workers' work? You see this a lot with things like temp agencies. Temp agencies, a lot of the time, a court would look at that and say, yeah, there's a joint employer relationship here because you're supplying the worker, and yeah, they're paid by this temp agency, but who's really determining who does the work? Is it the client of the temp agency or is it the temp agency? At the end of the day, it's probably the client, the temp agency's client who's determining the work. But one pays the fees and makes sure the schedule is there. So there is like a joint employer liability there. That's where it gets kind of tricky, is this temp agency thing, which is coming up a lot more these days, especially with younger people coming into the workforce. A lot of people will try a temp agency first before actually going into a job. So that wraps up that part. Our last, oh yes.
Can I ask a question?
Sure.
Would that also affect, there's like the newer things that are like popping up in DC that I think more maybe hospitality focused people are starting to use, like Snag or some of these other like kind of Uber for workers, like your dishwasher calls out, so you are, you know, opening up your Snag app and trying to get someone in. Would that be the same idea as a temp agency where it can be kind of the same, is it ultimately the same thing? Because we would be telling them what to do when they got there, even though they're taking care of all payment and we're putting payment to Snag, but Snag is paying the worker?
So that is actually a really good question, really good example. That actually might fall more into independent contracting because it's for a discrete project.
Okay.
And you don't know who's going to be available. You don't have one particular worker who is always going to be available whenever you need them. You don't know who you're going to get. You just know that you're going to get a body in there.
Yeah.
So that's going to be more of an independent contractor relationship. In terms of temp agencies, I'm thinking something that's slightly more long-term. Some temporary positions will last three months to a year in some cases, in which case, once a year's gone by, arguably there's a very strong case for joint employment. But that is a very good question. That seems to lean more towards the independent contractor realm. Any other questions? That was a really good one. Okay, so the last area that we're gonna hit is the workers' pay, and I have included some supplemental material for you. There is an IRS 20-factor list in your packet of materials, as well as the Form SS8. The one test we haven't talked about yet is the IRS 20-factor test. Partially because it's a 20-factor test. It's probably more beneficial if you guys have the list with you and can look it over in your spare time. The reasons why you would use the 20-factor test is very different from the reason why you would use the NLRB or Department of Labor's tests. Department of Labor testing is more to determine what your liability as an employer is and what duties you owe to the people who work for you. The IRS 20-factor test is going to be a question of, what do I need to withhold? Are they getting a W-2 or are they getting a 1099? That's what we're looking at. So it's a very exhaustive list. If there are ever any questions about whether or not I should be withholding taxes for my workers, please speak to your payroll company or an attorney. The Form SS8 is helpful, but I would use that as a last resort. It is a form that you would submit to the IRS when you say, I, in good faith, honestly do not know what my worker is. I don't know if they're an independent contractor or if they're an employee. Please help me. As the agency that is determining who I have to pay and how I have to pay them, please tell me if this person is an independent contractor or an employee. That is what that SS8 form is. So if you guys have any questions about that, feel free to let us know. Really, follow the DOL standards on this one because you're trying to protect yourselves against future liability for acts of people who work for you, or in the case of a lot of the civil statutes we ran through. Does anyone have any questions about any of this? No? All right, so with that, I am going to hand you over to my colleague, Jason Facci.
Thank you, Rochelle. Is everybody okay to still keep going, or do we need a break? We're all good? Very good. All right, good morning, everybody. My name is Jason Facci. I'm an associate attorney at Goldblatt Martin Posen. Thank you all for coming here today. Today I'm going to talk to you about wage and hour law and kind of some of the changes that we're seeing as of late. Wage and hour issues are particularly come up very often in the hospitality, restaurant types of industries. I know we have many of you in attendance here, big fan of a lot of your establishments, so thank you for coming here. So this will be particularly important to you, but really this applies to really all employers in DC and across the nation. So the first thing I'm going to talk to you about is the DC minimum wage, the DC tips minimum wage, how that factors into overtime, and then we'll go into some detail about overtime in general and some of the exemptions from overtime, classifying employees as exempt versus non-exempt, and some of the factors that you should all look for there. So starting with the first slide, DC minimum wage, as of July 1st, 2018, everybody knows that the DC minimum wage is $13.25 per hour, right? That is set to change July 1st, 2019 of this year, which will increase to $14 per hour. Make sure, this isn't included in the presentation, but whenever you do increase your wages for employees, that you provide that wage theft notification sheet that updates the employee on what their new rate of pay is, so you're in compliance with the Department of Employment Services requirements, which is a unique thing to DC. In terms of the tip minimum wage, that increased to $3.89 per hour last year on July 1st. That is going to increase again to $4.45 per hour this year on July 1st. And it will increase to $5 per hour by 2020. And as many of you know, if an employee's hourly tipped earnings when average weekly do not equal the minimum wage of $13.25 per hour, the employer is required to make up the difference to ensure that those tipped employees do receive at least the minimum wage. By show of hands, how many people here have tipped employees? All right, almost all of you. Very good. So this will be important to you. So the next thing I'm going to talk about is how to calculate tipped overtime, which is actually not as intuitive as people might think. We had some of these issues come up with restaurants recently, other people in the hospitality industry asking us, how do we calculate overtime? Our accounting firm is telling us one thing, I thought it was another thing. So we kind of boiled this down to what I think is the most simplified version and math formula that you can use when calculating what tipped overtime should be. So I'll go into detail about that now. So for the purpose of this example, we're going to just use the minimum wage as the starting point, or the minimum regular wage and the minimum tipped wage. Obviously, many of you may be paying employees more than the minimum wage or more than the tip minimum wage, so the numbers might look a little bit different for you, but for the purposes of this example, we'll use just the minimum wage. So everybody should know that the overtime rate of pay is 1.5 times an employee's regular rate of pay for every hour beyond 40 hours in a work week. So using that standard, 1.5 times the minimum wage of $13.25 per hour is $19.88 per hour. And that's just multiplying 1.5 times that rate. However, when calculating the overtime tipped wage, if we're going by the standard of $3.89 per hour, the overtime tipped wage is actually $10.52 per hour. And a lot of people ask, well, where does that number come from? So where that comes from is using what's called the tipped credit in DC. So although tipped employees receive, let's say, $3.89 per hour, they're actually, in reality, the employers are receiving a tip credit that allows them to only pay the employee $3.89 below the minimum wage. That tip credit is $9.36, which is just the minimum wage minus the tipped wage, and you get the tipped credit. So when calculating tipped overtime, common misconception is, well, do I multiply 1.5 times the tipped wage of $3.89 to get the tipped overtime rate? And that's actually incorrect. What you do is you still take the minimum wage of $13.25 per hour, you multiply that by that 1.5, and you get the $19.88. You always start with that calculation. From there, you subtract the tip credit from that overtime rate to get the overtime tip rate. So you're left with a formula of minimum wage times 1.5 minus the tip credit, and that equals $10.52. I know I just threw out a lot of numbers and math formulas for you, but it does make sense. You're taking the tip credit of, was it $9.36, which is the difference between the tip wage and overtime. Once again, this number may be different for you if you tip a little bit, if your wages are above the minimum wage. And that's how you get that $10.52. Does that make sense to everybody? I hope it does. Any questions? I'm happy to kind of run through that again. I mean, I don't practice math as much as I used to, so some of my math skills have definitely gone downhill. But essentially, that is what you do. You take the overtime rate of 1.5 times the minimum wage, subtract the tip credit. You're left with $10.52. Happy to walk through any other examples if you do have some of those. So now that we've brushed on overtime, I'll talk to you a little bit about sort of general overtime rules, who these rules apply to, where do they come from, and then some of the exemptions that you should all look out for. So overtime, the whole concept of overtime comes from the federal law, which is the Fair Labor Standards Act. DC has an equivalent version of that, but the Fair Labor Standards Act is sort of the minimum requirements. States are free to be more restrictive than that, but they can't go beyond the federal standard. So the federal standard there guarantees all workers the minimum wage and at least 1.5 times their rate of pay for overtime. Generally, FALSA, which is it's commonly known as, applies to employees of enterprises that have a gross volume of sales or business done totaling $500,000 or more per year, as well as employees that are engaged in interstate commerce. Now that might not apply to everybody here. That's the federal standard. Once again, there's a DC standard which encompasses more employees and more employers. But that is the eligibility requirements to be subject to the FALSA. We actually had a case fairly recently representing a company in federal court who was being sued for violation of this federal act based on failure to pay overtime. And we got that case dismissed in federal court because these basic standards, interstate commerce and gross volume of sales, were not met. So those are important things to look out for. That can move your case from federal court to state court, which can actually save you a lot of money in expenses, fees, court costs, things like that. And that interstate commerce standard is actually quite broad. That could be as little as making a phone call across state lines, ordering products from another state and having them be delivered to you. That can satisfy the very broad requirements of interstate commerce. So that's also something to look out for. And I think when faced with an issue like this, you definitely would want to seek the advice of counsel to see if some of these eligibility requirements apply to you. So it's estimated right now that 72% of employers are actually not in compliance with the Fair Labor Standards Act. Now that's a huge amount. Mostly that comes up in situations where employees are misclassified as being exempt from overtime when in fact they're non-exempt. So we're going to talk about some of those factors and what you need to consider when determining whether or not an employee qualifies for overtime. Sort of the 5 basic overtime exemptions that exist are known as the white-collar exemptions, and they're called that because these are typically jobs that are in the white-collar industries, so executive positions, administrative positions, professional positions, then the less common outside sales and computer employee exemptions. So those are sort of the job duties that one needs to have in order to be exempt from overtime, but that's just one of 3 factors that need to be met when determining whether or not an employee is exempt versus non-exempt. So the 3 factors there are, it's called the salary test and the duties test. The salary test has 2 parts. Number 1, in order to be exempt from overtime, you need to be paid on a salary basis. So not hourly wages, but an overall annual salary. Not only do you have to be paid a salary, but you have to be paid the minimum salary threshold, which currently is $23,666 per year, and that equates to $455 per week. That standard has been in effect for roughly 20 years or so. You might have heard that the Department of Labor has been seeking to increase that salary threshold since it's a little outdated at this point. We're going to go into some detail about that towards the end of my presentation, but for purposes of right now, the salary threshold is $23,660 per year. So those are the two factors of the salary test. The last factor is the duties test, which are those white-collar exemptions that I talked about, the executive employees, administrative, professional. So job title alone is not sufficient to meet that job duties test. So just because somebody has the job title of manager or executive doesn't necessarily mean that they meet those requirements. So we'll talk about some of the, let's go into some detail about the actual job duties that need to be performed in order to meet that test. So starting with the executive exemption, the primary duty of this executive needs to be managing the enterprise and at least directing the work of 2 employees. Not only that, they have to customarily and regularly have the ability to hire or fire employees, make recommendations for promotions, make recommendations for hiring and firing as part of their regular primary job duties. And when looking at this, all factors are considered. So no one factor may be determinative. All factors will be considered when looking at whether or not this job duties test will apply. So that is the executive exemption. Any questions about that so far? Okay. Moving on to the administrative exemption. This one encompasses a lot more job duties. For an administrative employee to be exempt from overtime, once they meet that salary test, their primary duty must be the performance of office work. So this isn't going to be, manual work. The example that the Department of Labor uses is being on a production line. That's kind of the obvious example of this is not an administrative employee. So their primary duty must be kind of helping with the general, running of the business. And their primary duties have to also include the exercise of discretion and independent judgment when performing matters of significance. So what does that mean? So some examples that the Department of Labor gives for administrative job duties could be, as I mentioned, assisting with running the business. That can include accounting, safety and health compliance, budgeting, purchasing, public relations, labor relations, government relations, advertising. All of those types of job duties are examples that they give. They're not exhaustive. There could be many more. So you definitely want to, read the guidance that the Department of Labor puts out. They have excellent resources online, or consult an attorney to determine if some of these job duties are met. And in terms of the exercise of discretion, that essentially means, does the employee have the authority to deviate from the standards that they're given, or deviate from whatever their assignment may be? Do they have discretion to waive certain aspects of their job duties, things like that, kind of on the go if they're talking to a customer or employee, if there's certain standards that need to be followed, if some standards do not apply, do they have the discretion to essentially waive some of those? And we can go into examples of that if you all like, if you have any questions. The professional exemption is the other big one. This one is a lot more straightforward. This is going to apply to all of your sort of learned professionals. So anyone that requires a degree from like a license, like a bar license. This would be your attorneys, your architects, your accountants, things that are recognized as learned professionals. They are exempt from overtime. And then the two less common ones are outside sales exemption and computer employee exemptions. Outside sales are going to refer to people, it's exactly what it means, people that are engaged in sales with with customers, working on contracts that primarily work outside of the primary place of business for the employer. Computer employees, also pretty straightforward there. Those are going to be anyone that works in the computer field doing any kind of software analysis, some IT work, things of that nature. So all those employees, if the salary test is met, they will be exempt from overtime if they meet those basic job duties. Any questions about the overtime exemption so far? Very good. So as I mentioned at the beginning of sort of my overtime presentation, the Department of Labor has been seeking to update some of these laws because they haven't been changed in roughly 20 years. Mainly the salary threshold has been some debate. So I think it was at the end of 2016, the Department of Labor proposed to essentially double that salary threshold in order to be exempt from overtime, raising it from $23,000 a year to about $46,000 a year. And that would have reclassified millions and millions of employees. That would have caused employers potentially a lot of issues since this law was going to come into effect shortly after it was proposed. This would have left employers kind of in a situation not understanding if, I guess, having to pay overtime essentially to a lot of their staff. This could have been a burden. So that law was actually halted by a Texas judge at the end of 2016, I believe, saying that the Department of Labor exceeded their authority, that they can't do this before it goes through a proper test and analysis by Congress. So that law didn't go into effect. Just recently, in March of this year, the Department of Labor has proposed a new law increasing the salary threshold to, I believe it's $35,308 per year. Now this will result in less of a, I guess, reclassification of employees, roughly about 1 million or so workers. But it is significant. It's not law yet. This is still proposed, and as I mentioned, it would increase to $35,000 a year, which equates to $679 per week. Actually, as of about 2 weeks ago even, the Department of Labor is continuing to add to this proposal. What they're seeking to do is change the definition of overtime rate of pay, which hasn't been updated in about 50 years. What the Department of Labor is seeking to do is exclude certain employee benefits from calculating the overtime rate. So what that means is if your employee, let's say, receives a transportation benefit of $25, per week that's added to their paycheck, or a gym membership, or tuition reimbursement, things of that nature, normally when they get that paycheck, their hours, you would divide up the hourly wage rate that that employee has, and that's how you would calculate overtime, by multiplying 1.5 times that hourly rate. The Department of Labor is looking to exclude those benefits from the calculation of the overtime rate, which actually would result in employers paying less money in overtime. So once again, this is all just proposed on the table. This was about 2 weeks ago. So we're following that, and we're happy to provide updates when when that law does take effect, or if it is finalized. But that is something to look out for. So how are we going to survive this new overtime rule? Oh, sorry, we have a question. Yes.
When do you think this law will be decided on?
There's really no way in knowing. It probably would be at least a year out before it would take effect, I would think. But it's difficult to say. The president also can jump in. I think with the last overtime rule, when Obama left office, Obama was actually trying to fight this decision from the Texas judge to halt this overtime rule, and then when Trump took over, he stopped pursuing the halting of this overtime rule. So there are political factors involved as well, but it's something to look out for. I'm sure there'll be some debate in Congress about it, so definitely stay tuned. But there are steps that you can take to be prepared when this overtime rule does take effect, and I put those on my last slide here. One could simply be just raising an employee's salary to the new minimum threshold of $35,000 per year. That might actually be cheaper than paying employees overtime if they're paid less than that. The other option is to just stick with, roll with the punches with this new rule and pay employees overtime if they work more than 40 hours a week. Another option could be to reorganize workloads, spread out the work to ensure that nobody is working more than 40 hours, so you can avoid that extra overtime. That would require keeping track of employees' hours, and that's something that you may want to start doing in advance as we get closer to this rule. I don't think action needs to be taken yet, but when they do announce that this rule will take effect, I think we would recommend examining how many hours your employees are working, how long does it take to complete certain projects, and then it may be needed to adjust schedules and adjust workloads in order to ensure that all work is completed within 40 hours in a week. The last option that you can use, which this proposal would allow for, is providing up to a 10% bonus to employees per year to meet that salary threshold. So if your employees if the new minimum threshold is $35,000 per year, you can actually pay them roughly, instead of increasing their salary up to the $35,000, increase it to 10% below that, and then at the end of the year, essentially provide them with a 10% bonus to meet that minimum salary threshold. And that's another way to sort of satisfy these requirements with it being a little less burdensome on your businesses. So that essentially takes care of the new overtime rules. As I mentioned, keep a lookout for that. And yeah, I'm open to questions.
To clarify, so someone works 12 hours one day, but ends up with 36 hours for the entire week. It's not an overtime position, correct?
Correct. So it's 40 hours per week, and overtime is paid on every additional hour after that 40 hours. Yes.
I do. In reference to the 10% proposal at the end of the year, the note here says either bonuses or incentive pay or commissions. Would you have to do that if you base the commissions or incentives on meeting certain goals? Is that a way to not pay that amount, or do you have to pay it automatically? I'm just saying, if we're going to say that incentive pay or bonuses or commission, those are usually based upon goals being met.
Merit, yeah,
so how would that work?
Yeah, so I mean, it really would depend on the position, but these bonuses would need to be sort of based on some kind of incentive, commissions. If goals are met, then that 10%, you can apply a 10% bonus, up to 10% at the end of the year, yes. I think do we have another question in the back? Or? Yeah. Yes.
The minimum salary threshold, does it apply to any particular job categories, or it's just anybody in that?
Yeah, that is across the board. So that minimum salary needs to be met in order to be exempt from overtime. It's not, it's not the minimum wage or anything like that. It's just in order to meet that salary portion of that three-part test, an employee would have to be paid the $35,000 to be exempt. Yes.
Going back to the tipped employees minimum wage, when it says, I understand it's average weekly, so if we're paying on a bi-weekly basis, like our payroll system automatically calculates it for us, but it's over the 2 weeks. So do we need to go back in and make sure that in a single week they were making the correct earnings? Or since it's average weekly and we're paying on a bi-weekly basis, it can be between the 2 weeks?
Right. I think if they're meeting since they get paid on a bi-weekly basis, as long as the minimum wage amount is met at the end of that pay period, then you would be in compliance. Yes. Any other questions? I'll be around here. My business cards are up front, so if you have any other questions, during the break or after the presentation, feel free to come talk to me or shoot me an email. I'm always happy to help. Thank you for your time. I'm going to now turn it over to Mr. Hilgers, but I think we'll maybe take a short recess first.
Yeah.
So everyone can kind of mingle and network. We'll take about a 10-minute break. Does that sound good? All right. Thank you very much. Sure.
For what you've all been waiting for. I know you're excited about this new topic. I've heard lots of buzz in the hallways and on the Twitter and all around. Universal paid leave is coming, so we are the guinea pig for this brave new program. And Kevin is prepared to tell us all about the money that all of us are going to be paying out in additional taxes starting on or about July 1, 2019. Be sure to ask Kevin lots and lots of questions. And without further ado, I'm going to hand the floor over.
Thanks, Tom, and thanks Rochelle and Jason for your presentation. One thing that Jason's presentation reminded me of, in particular, with all this wage hour business, is that for all these issues, you're going to hear, you may even hear different things from different professionals searching online, and with the overtime tip credit, you hear all sorts of different things when you Google or you talk to your payroll company. But there's no substitute for looking at your materials here for reference or consulting a professional about things. So we're always happy to help with that. So my name is Kevin Hilligers. I'm associate at Martin Posen, and I'm going to say a few words about DC's new universal paid leave program. There's a lot of slides here, a lot of information here, but unfortunately we don't really know exactly how this is going to pay out. We don't know the finer contours of this because the law was passed I think in late 2016, but the rollout has been a little slow. We don't quite have the regulations that are really going to determine how claims are processed. So there's a lot of important information forthcoming that we just don't quite have. So, like Tom said, we're all going to be, especially employers, are going to be the guinea pigs here. So, really interested to hear your questions and comments and concerns, so that we have an idea of what the particular areas of focus should be with this law going forward as it rolls out. So just to start off, a little bit about the current lay of the land. Like I said, the law was passed at the end of 2016. There's supposed to be regulations in progress. They're going to do a couple iterations. DOES has last year, I think there was, 50 pages of proposed regulations covering everything from tax collection to claims administration. Then that was put up for comment, and then nothing happened. And then DOES said, okay, we're going to break this out into two components. The first is on the tax collection part. We'll issue those proposed rules, and then we'll do claims administration, benefits administration, and separate rulemaking. So late last year, DOES issued these tax collection regulations, which really just track unemployment, so that there's not too much new information there. And so those were proposed for more comment. Still nothing happened. The rules had to go to the council. So just at the start of this year, DOES issued a proposed final rulemaking to the council for 45-day review, and unless the council affirmatively acts, those tax regs are going to go into effect May 16th this year. But again, those regulations don't really get into the real interesting part and potentially complex part, which is how are we going to process claims, how are we going to process appeals if the employees don't agree. So May 16th is when that comes. As you know, on July 1st, 2019 is when the 0.62% payroll tax is going to kick in. So that's going to be handled similarly to the UI tax. There'll be an online portal. It's going to be the default position for paying that quarterly tax. Again, 0.62% beginning on July 1 of this year. I understand DOES has finalized or is about to finalize its IT contractor for this. So, July 1 is coming up pretty soon, so there's sort of a rush here at the end to get the predicts in place and to have the actual mechanics of the technology in place to make this work. So, we haven't seen exactly how this is going to work mechanically, let alone the particulars of the regulations. And DOS has sort of pushed all these deadlines back, but the next part that I'm personally looking forward to is DOS's proposed rules on benefits and claims handling. So it's going to get into the issues of, what are all the documents that people are going to have to submit, how's the DMS going to adjudicate this, any additional guidance on what a qualifying event is. That's going to be something that I'll be watching for pretty closely. Then of course, 1 year from now, a little over a year from now, on July 1, 2020, that's when employees are going to be able to start receiving benefits. So the tax kicks in this year, and then in 2020 is when the benefits kick in. So that's the lay of the land. Any questions about any of that?
Yeah,
Yeah.
Hi. But this 0.62% payroll tax, is that a constant, or does that apply only to the taxable wage base?
I think it's phrased as a tax on the wages of the covered employees, so the employees who are eligible for it. So that's I think that's the way that the statute is phrased.
Is it 0.62% of every dime a person earns, or only up to a certain level?
It's point. Let me confirm that, because you're right. The benefits end after a certain point. I believe they go up to any amount. But that's a good question. Let me confirm that. All your questions are going to be great because we just haven't had practice with this, so we don't really know. What are the issues people are going to have. So that's great. All right. So, just the basics of what paid leave is all about. It's going to allow employees for certain employers, really all private employers in D.C. It doesn't apply to the federal government, doesn't apply to the D.C. government. D.C. government has its own paid leave program for its employees. And it's going to allow self-employed folks to opt in if they so choose. It's going to allow them to receive paid leave benefits after having a qualifying event. There's 3 types of qualifying events. One is personal medical, second is family medical, and then also parental leave. And the benefits will vary. The length of benefits will vary based on the type of leave being used. So it's 2 weeks for medical leave, 6 weeks for family leave, and 8 weeks for parental leave.
Is that a one time, or does it refresh after 5 years?
I believe it's every 52 weeks.
Yeah.
Let me confirm on that too.
Sorry.
But I know what FMLA is every 2 years, I think. Yeah, let me confirm on how often that can be used. Great questions. You see that the average weekly benefit, just so you know what your employees are going to be entitled to. It's you look at the employees' average weekly wages, and they receive 90% replacement wages up to 150% of the minimum wage times 40. So it's looking at like 150% of someone making minimum wage for a full-time week. So it's sort of it's graduated like that. So 90% up to 150% of the minimum wage for a full week. And then if you make above that for a week, it's 50% of those additional wages up to a maximum weekly benefit of $1,000. And the onus is on the employee to file the claim, so it all goes through the UES for the employee.
Question.
Yeah.
So let me make sure I understand this whole thing. So the 0.62% that's paid, and that's on the dollar that every person earns, that is going to cover the benefit that's being paid to the person if they file for the claim, and then the tax benefit goes to help the employer to cover that?
The employer doesn't have to pay anything. That was one of the debates about this. How is this going to interact with, with many employers said, I provide paid leave for my employees. I'm fine handling it this way. But the decision of the council was to say, no, we're going to have this mandate. Every employer pays this 0.62% tax, and that goes into the paid leave fund. and then DOES will pay out those benefits, just like they pay out UI benefits and other benefits. So, yeah, the employer doesn't have to pay anything. There's no, account for a particular employee. Just all goes into the pot, and then the benefits come out to the employees.
So there's no, I thought I saw something that said that there's something after the year where the employer, there's some kind of benefit, or is that when the person, the actual employee can take, file for the benefit? So the employer, you're saying, doesn't pay into it, but they're paying the tax at the beginning.
Employers will pay the tax as long as this law exists on a quarterly basis.
And
right?
so is there any way in the law at the end of the year or quarterly when the employer does taxes that there's some kind of benefit for paying into this fund for that? Or
Well,
not written yet?
the council has said that the theory behind this law is that this is great for employees, of course, and it also makes DC, a great place to work and attract employees, and it can even the playing field between large employees and employers. But not everyone may agree with that. But yeah, there's no
So that's supposed to be the benefit.
the actual benefit.
Employer, okay.
The money benefit only goes to the directly to the employee. Yeah.
So the funds in this account keep accumulating forever, let's say. So if I have no claims, I'm still putting money into this bank, and there's nothing that as an employer, we can benefit from.
Yeah, it's not like UI where it might fluctuate based on your claims experience or other insurance. It just gets paid in, and that's a good point too. Is that time will tell if that's going to be adequate to pay out all the claims.
And do we get some kind of report saying that here's the money that's going to this particular account, and here's what your balance is, or here's what your contribution is from July 1st through whatever?
That's a good question too. I haven't really dug into the proposed regs that are before the council now, but that would be something that's in there too, and I'll take a look at that. So, because as you know, like for UI, you can track your account, so to speak.
I would think also along that same line, it being that it's 0.62%, again, time will tell once they start accumulating, money in this, and depending on how many people use this benefit, if they should either set a cap or a max or something of how much money they put into the coffers here to realize that, wow, we've got a good surplus now. Maybe they drop that percentage from 0.62 lower for us to have to pay in if they've got an excess amount of it.
Yeah, that's not in the law, unfortunately. So it would take further action by the council to change that. The only thing that's automatic in the law is that the minimum wage, or at some point benefits will scale up with CPI for the metro area. So it seems more likely that there won't be enough money in the bank. Yeah.
I have a question, because it looks like our payroll company has actually already started withholding this tax. If this isn't taking effect until July, should we be, I guess, asking them not to do that at this point?
Think about that. So my understanding was that the tax collection begins on July 1, so that would be the third quarter.
Okay. Yeah, there's definitely a paid leave tax that just appeared, I think, on our last payroll.
Okay. Yeah, that's a great question. I'll pin that down too.
Okay.
Which payroll company?
Corporate payroll services?
I remember there was something about like as of April 1st, you had to start tracking it.
Yeah.
But then the tax won't be paid until the third
Due?
quarter.
Because
So it may
Is that
just be
correct?
that, I remember hearing that, I don't know if
Take it
that's.
out on the 1st of July.
Did you
but they
hear anything
already
about
start
that? Like,
Calculating it.
we had something similar by April 1st, we had to start tracking, I guess, like.
You have to start tracking employee data and salary. So
Right.
you have to create a salary record, like of what I'm paying to which employee. You don't have to-
But the tax doesn't start till July. Yeah.
Yeah,
That's
yeah,
our fair
that's, I mean, it wouldn't surprise me if your payroll company is starting to make that transition, but
Right,
I'm
but I'm
pretty sure
wondering if
that's
maybe
not
that's
live as well. We'll pin that down. Yeah,
Yes, on this benefit calculation, is this based on base salary or base wages, or does their overtime come into play?
it's based on their average weekly wages, however, they're, you know, as long as their wages, that's gonna be the calculation. But it is capped at $1,000 per week.
And on the average weekly wage, is that over a specified time period or simply do I look at the last year, the last 3 months prior to the
Previous
claim?
52 weeks, I believe.
They can only claim once a year? Can they only claim once a year for whatever that's period? Or let's say somebody gets sick, then they have a kid, you know, how many times, you know, based upon the event, do they get to apply for that?
Yeah, that's one thing I'm not gonna pin on. That's a great question, I'll confirm.
And wages include tips, correct?
Right, that's a way, so, yeah. All right, so let's jump a couple slides ahead, because there's a lot of information here, and dig a little deeper into what the various qualifying events are, so that can offer, that can entitle an employee to apply to DOES for claims. So I said that there's qualifying medical, family, and parental leave, and each one has its own requirements and its own length of time that people can use them. So qualifying medical leave is for the diagnosis of a serious health condition on the eligible individual. So that's the actual employee is experiencing a serious health condition. Then it's 6 weeks for qualifying family leave event, which is not the employee having a serious health condition, but one of their family members experiences it. So it's time to care for that family member. Then the last one is 8 weeks for qualifying parental leave. So that's bonding associated with birth or adoption, foster or legal placement of a child. That's an area where these regs from the UAS are going to be really helpful, is to put some meat on sort of the skeleton that's in the law itself. You know, what does it mean to bond? You know, what's the serious health condition? There's a little bit of guidance in the statute on that, but not quite as much. How do you prove that you're having this qualifying event? That's all stuff that's really going to be elaborated on. Yeah.
Elaborated on and managed by DOES. We, as employers, will not be making that distinction. Someone will put in there, I'm going to take 4 weeks of my family leave event, give notice to employer. We'll know we need to cover that schedule, however we do that internally. But then as far as it qualifying or proving that, that is all on DOES.
Right, DOES will make that determination. They'll ask for documents. We get to that in a minute. So similar to the way UI claims are handled. So they'll bring the claim from the employee, and then the DOES will contact you saying, hey, is this all correct? Then you'll have a chance to respond. Yeah, the regs will elaborate on exactly what you should expect as far as documents and supporting documentation, and how to handle any disputes about it. I know our firm does a lot of UI claims, and I think we may be getting into this as well when it starts to kick in. But that's really the big unknown is, you know, how are these disagreements between employers and employees going to be handled? What are going to be the common areas of dispute? So, yeah.
That was my question, is there going to be an appeals process for this?
Yeah. There's an appeals process in the statute that actually is for the employee, and the regs that have been proposed so far don't get into that. Actually, when DOS proposed rules way back last year and actually eventually scrapped them, they didn't actually provide for an employer appeal, which is a little, I mean,
One-sided.
just a little one-sided. However, you know, we believe that just under you know, the DC Administrative Procedures Act and other DC laws, of course, an employer can appeal a decision by an agency, but there wasn't any you know, quick process like that, but so something that we should see in the claims regs that are forthcoming. Yeah.
If the employer is paying the leave anyway, are they still eligible to claim a file with DOES?
Yes.
Okay, so it's additional to what the employer is paying?
Right. Nothing prohibits them from, nothing prohibits employers from continuing their own programs, but they still have to pay into it.
As a follow-up to that, man, for instance, if I have 3 months of accrued leave on the books, will I be mandated to work down my accrued leave that my employer already has on the books for me, as opposed to filing a claim for universal leave and keep my accrued leave on the books?
Good question. I know under FMLA in DC, it's the employee's decision whether they want to work through their accrued leave or not. Yeah, that's a good question. Let me think about that one. Well, I know I said that DOS is going to have regs that are going to elaborate on the meanings of these qualifying events. But there's a little more information in the statute of what a serious health condition is. It's continuing treatment for incapacity, so it's not sick leave. It's certain events that require inpatient care in a hospital, home care, that sort of thing. Moving on, just reiterating some of the tax points. One interesting thing about this, look at slide 44, is that this law doesn't actually change FMLA expressly. So as you know, DC FMLA only applies to employers with 20 more employees, but in effect, it extends something like FMLA light as far as the leave that people are entitled to. Of course, requires payment. FMLA is not paid. But even though FMLA only continues to apply only if you have 20 more employees, paid leave applies to all employers. So in effect, even though if you're not subject to FMLA, you still need to give people the paid leave. So it's sort of a backdoor extension of FMLA. Yeah.
So unemployment payments has a threshold. You have to be employed for X amount of time before you're eligible for unemployment benefits. Is that the same for this, or is it just open season?
Yeah, it's 52. If you look back at slide 40, eligible folks are those who have.
It's a 50% of
52
his
weeks.
work time. So if in the last 52 weeks you worked, 26 weeks, if you worked, 14 of those weeks for an employer, that makes you eligible for full benefits?
The 50% goes more to whether someone's employed in the district or not. So if you have an employee who works for you in the district all the time, then they're going to be covered as long as they've done that for the last 52 weeks working for them.
Okay, so you have to be employed by the same. You have to be employed for a year before you're eligible for this. Is that what that says?
Let me pin that down, because I know the statute says 52 weeks working for a covered employee. But that's a good question. Should it really? Because you can work for multiple employers the 52 weeks, and they're all covered employers, but you've been employed by various ones. Does that make sense for your most recent 1 month employer to that? So let me pin that down as well. Is it one covered employer for 52 weeks, or can it be multiple? So back to 44 about some of the interaction with some of the basic leave policies for employers in DC and federal government. The benefits run, similar to FMLA, federal and local. These benefits run concurrently, so it's not like you get your 8 weeks of parental paid leave and then your whatever weeks of DC or federal leave. They all run concurrently. Yes.
Do you know what would happen if, let's say, my FMLA job protection expires and then the employer moves to fill that position?
So if you're on FMLA,
Yeah, and the employer says, okay, we don't have to protect your job anymore, and we're going to move forward with separation, and we're going to fill that position because we need a worker in that position.
right, so if you exhaust your FMLA, and FMLA, of course, lasts longer than universal paid leave. So you wouldn't even be dealing with universal paid
Okay.
leave at that point.
All right.
But yeah, under FMLA, you're only entitled to the leave that it provides. So if you go beyond that, then you may be able to go forward in a different direction. Just skipping forward a few slides. If you look at slide 48, that shows you the way the tax breakdown and benefit breakdown is going to be when the program launches. You can see, for each for employees at various wage levels, what your tax is going to be, and then the benefits that they'll be entitled to. And then, as noted in that asterisk, the maximum benefit is tied to CPI for the metro area, so that's going to automatically scale up. Again, adding to that question, is this 0.62% tax, is that going to be enough to pay for it, or is DC going to come back to revise that? Next couple slides, really to probably the biggest known right now that employers may want to get a jump on is the notice requirement, because the notice requirements for paid leave are a little different from some other laws. Notice is required at not just posting in a conspicuous place in the workplace, but it also has to be noticed at the time of hire. So when you give your employee handbook and they sign their acknowledgement, you want to add this to the list of all the DC laws that they should be aware of. It also has to be given annually to all employees. So every year you may give a memo to employees giving all the required notices. So this would be part of that. And the fourth point is that you have to give it to the individual at the time that the employer is aware that the employee may need paid leave. So if they think someone's aware, if you've already given the notice, it's already posted conspicuously, an additional notice is required. Next slide, there's also a bunch of record-keeping requirements. And again, this is for the claims processing point. So your pay stubs, your work schedules, communications, then additional information that will probably see DOES required by rulemaking this year. Just as there's notice required to the employees, the employees have to provide notice to the employer when they're going to use leave and file the claim. Some of the details for this are going to be coming out in the regs, but just the basics of the law. If the leave is foreseeable, 10 days notice. If it's unforeseeable, oral written notice before the start of the workshop, or in case of emergency, oral written notice within 48 hours. So plenty of flexibility there for the employee. This notice has to include the reason for the absence and then the expected duration of the leave. So that's the employee's obligation to request from the employer. The next couple of slides, once the employee gives notice to the employer, there's the separate DOES claims side. If you look at 53, that just shows you sort of the general time frame that this would happen. Employee will file the claim, and within 3 business days, the DOES examiner will notify you, the employer, of the filing, and the employer will have a chance to respond. That's where you're going to see potential appeals to OAH, which if they do things right, the DOES will allow employers to appeal the decision. And And then DOS is going to issue their initial determination within 10 days of the filing, and then make the first benefit payment within 10 days of that determination. So for a 20-day process. And of course, like I said several times, we're looking forward to these DOES rules that are going to say a little more about how these payments are going to be processed. The next couple of slides are about appeals to the Office of Administrative Hearings. Like I said, they only give the employee side of the appeals as of now. There's certain things that employers should be aware of. One thing is that the council decided to have a rebuttable presumption that the employee is eligible for benefits if the employer makes certain mistakes under the law, such as not maintaining the records, or if you're not paying your taxes, or if you're not providing the notice. That's going to shift the appeal more into the employee's favor.
I have a question.
Yeah.
So if a person says they have some kind of conditioning, they need to be out, they can file the claim through DOES, but can they still say to the employer that, hey, I need to be off, and file FMLA or claim that and be off during that time period while the determination is being made, and if it's made then in their favor, then they subsequently are able to take that leave as well.
Right, so they have to give notice to the employer depending on whether it's foreseeable or emergency, that standard. And then they can go forward and file the claim with DOES, and assuming the employer doesn't object or appeal to that, then they're entitled to it. As far as interaction with FMLA, that's a separate issue, and they'd have to go through the appropriate process to get their DC or federal FMLA, and then those would run concurrently. So it's not like you
They have to wait, so you're saying they don't have to wait if they're going to do an FMLA? So they can just say, hey, I need this, and provide the documentation. It may be enough for that, but there may be some question on DOE as far as whether or not that's legitimate.
Yeah, well, DOES wouldn't be looking at the FMLA, right, because they're a little bit right. Different. I mean, the standards seem to be a little higher to be able to provide all this documentation
Now, I'm thinking about it from the employee standpoint, that they're going to go ahead and be off from work, and under the FMLA saying I have these rights. And maybe I'm not thinking about it right, but then they still apply for the benefit through DOES. And they are separate, and the team member or employee knows it's separate. And they take the FMLA and say, I have these rights here to do this. I've given you notice, I've given you whatever. And then they still additionally will separately file DOES. So in that instance, they may do the FMLA, run that out, and maybe the appeal process takes long. When it comes into, when the appeal is approved, then they have that time period to do the leave under DOES. I don't know what.
Right, I think, so a few things. So
separate.
One, there's a 1 week waiting period before getting paid leave benefits. So there's that a little bit of time. But again, they're going to be concurrent, so it's not like you can take your FMLA and then extend it somehow through the back door. Gotcha. by taking paid leave. Yeah.
One rare scenario by, is there any provision where, let's say I'm the employee, I notify my employer today I have, I believe, I have a medical condition and I'm going to apply for universal leave. And I see here that DOES has 10 days from date of filing to issue a determination. If DOES issues that determination within 10 days, or issues a determination at all, as we know they never meet deadlines at DOES, and finds that they decline my request for leave. Meanwhile, I have not been at work for the last week or two. Is the employer in any way barred from taking action against the person's employment for, in this case, saying I'm applying for leave, the leave falls apart, meanwhile I've been AWOL, no come, no show for the last 2 weeks?
I think in that case, I would be wary of getting into the prohibited actions such as interference and retaliation, because the way that the statute set up is that there are provisions to prohibit, bad faith or fraud or relying about your claim on the employee's end. So if that was the case, that it was clear that they were submitting a fraudulent claim or it was in bad faith, then I think you might be in a better position to take action against the employee. But absent that, I mean, the law has a provision prohibiting employers from interfering with or retaliating against someone for exercising their right. And I think the argument on their end would, on the employee's end, would be, I made a good faith claim. DOES disagreed, but that's the case. And so they would say, well, if you were to terminate me or suspend me or whatever it may be, that would be unlawful retaliation.
So just a variation, the person then fails to provide the documentation requested by DOES. Because we see it all the time with FMLA, people say, I can't get it, I can't get it, I can't get it. You give them deadlines, extend the deadline, and ultimately say your employment's ended for failure to comply with the requirement to provide the healthcare provider certification. And I don't believe in that case it's viewed to be retaliation, but I can foresee that happening frequently where people file claims, fail to follow through as simply a means to get time off.
Mm-hmm. Yeah, I think I might treat that similarly to what you would under FMLA. That hey, you had your chance to do this and you never did. It's clear that there was no good faith effort to do it because you never, DOES needs to have these documents to process it, and if they never come through, it would seem like that would be.
It isn't thinking ahead, then would DOES be then obligated to provide the employer with evidence of what the employee failed to do? Or is that protected information, or is it not? Will they share it with the employer? Because I foresee, I work in unemployment, so I foresee then being a situation where you're at an unemployment hearing, and the decision to terminate, we relied in large part on decisions made by DOES that the person failed to provide documentation to substantiate the need for the leave. And our hands would be tied in that case if we don't have proof that the employee in fact had failed to comply with DOES regulations. But I guess maybe that's a rather.
Yeah, I mean, I'll have to check back on the statute for that, because I know that the DOES has to come back to the employer saying, hey, we've received this claim for benefits, and all these documents are required. And I know that there's a bunch of releases for privacy that the employee needs to file as well. So I believe that our page will be shared with the employer. But no, that's a good question. What documents do the employers have the right to see when the claim comes through? Yeah.
I think my question is somewhat in the middle, or some kind of an amalgamation of these two. I guess if someone goes to DOES and is filing a claim, the claim is denied. At that point, they have 10 days of leave accrued through DC's paid sick leave. So at that point, if their DOES claim had been denied, they could say, I want to put in those 10 days of accrued sick leave if they've been with your company, right? Because they could use that technically for some of these things, even though this is a larger benefit group.
Right, as long as they were.
Right. So then they're denied because they don't put in the paperwork. You would pay out that 10 days of sick leave. Even if it's ultimately denied by DOES, that's still a shorter period than under FMLA. So even if the claim was denied by DOES, you would still have the longer, ultimate, waiting period's not the right word, before you could terminate, because it would be under FMLA, which has a longer out-of-office period protection than DOES.
Right. Right.
So just because a claim is denied by DOES and they haven't come to work wouldn't be a reason to start an unemployment proceeding, because even if they've been denied under DOES, they still have the larger protection of FMLA for a longer period to be out.
Right, if they're for whatever reason denied paid leave, but
Yeah.
they're great, but you agreed to FMLA, or they're entitled to FMLA, then they're allowed to run out the FMLA unpaid or using whatever sick leave they may be entitled to. But yeah, it's interesting to see a situation where someone is not entitled to paid leave, but is entitled to FMLA. But
Well, we just don't know what those we're not sure where to be yet because it's so broadly defined.
Right, right, and there's so many unknowns that are still forthcoming. Yeah, I can see there being a lot of, you know, like with some of the earlier part of the presentation, we've had, you know, decades of case law and decisions by NLRB and DOL guidance who've been, you know, litigating this stuff for decades. But with this, you know, we don't know. And unfortunately, the burden's going to be on the business community in DC to help hash out these things. Yeah, so just going to the last couple slides, you know, some of the prohibited provisions. Like I said, you know, applicants are not allowed to make false or misleading representations to get benefits, and if they do, they can be disqualified for a long period of time, for 3 years. If benefits are paid erroneously or as a result of willful misrepresentation, or if the claim is rejected, DOES can seek to get repayment from the individual. And then it has to, once it obtains repayment, it has to distribute the amount back to all the covered employers, proportionally. I guess that also is a question of what if they cannot recoup the money from the individual who, you know, made a willful representation, or, you know, beyond just having their claim denied. I know that that's an issue with certain nonprofit employers with unemployment, is that, you know, they pay the claim directly, and if it turns out that it was erroneous or it's overturned in OAH, you know, they got to work with DOES to get that repayment, and it can be a challenge. Yeah.
I don't understand the last bullet. It's like, I thought you said that the employer doesn't pay the benefits directly, that it is administered through DOES. So how would it be repaid?
Oh, sorry, this is DOES. DOES is re-seeking the repayment back to DOES. So it's a stick against the claim. So yeah, it's not going back to the employee because the employee paid the tax, but this is DOES making itself whole to some degree. So thank you for that clarification. Then last slide, you know, going to the usual prohibited acts, interference, retaliation is prohibited. There's going to be a lot of overlap with the DC Human Rights Act here because parental family medical leave will touch on, you know, one or more of DC's 20 protected traits for employment discrimination. So there's a lot of overlap here. You know, similar to I think DCF MLA, there's a 1-year statute of limitations on, you know, bringing an administrative or complaint or lawsuit under the law. So you know, that's something that's going to be something to watch down the line. You know, is there going to be any case law developing out of this from lawsuits on either side? And just the very last bullet point, DOES is authorized under the statute to undertake investigations and issue subpoenas and obtain documents in order to ensure compliance. So that's the brave new world, the unknown world of DC's new paid leave statute. So I really appreciate all the questions, giving me a lot of things to think about that, you know, are just hard to think about unless you really get out there and see what's going on, what are people's concerns. Because it's one thing to have the law in a book, we don't really know what it means until it comes out into play. So all we know is that there will be a 0.62% tax starting out in July 1. But in the meantime, I really appreciate all the questions, and you know, we'll take a look at that feedback and information to the extent that we can, given what we have, and we'll get back to you. But again, thanks so much for your time, and I think that's it. So thanks to TLF and Michelle for hosting, and thanks everyone for coming out. Thank you.
Thank you, everybody. As you can see, Universal Paid Leave, we're all still working out the kinks, and there'll be a lot more information sessions that the government's putting out and that we'll put out in the future. I actually think that there's a town hall meeting at the convention center on Tuesday that DOES is putting on for everybody to learn more about paid leave. That's going to conclude our seminar, though, for today. Tom and Michelle apologize for not being here at the end. They had to run to a meeting. But we wanted to thank you all for coming. I think our next seminar is tentatively scheduled for July 19th, 2019. So we hope.
Topic to be determined.
Yes.
So if you have any topics you'd like for us to address next time, we'd be happy to hear from you on that.
Absolutely. So once again, our business cards are all up here at front. Rochelle, Kevin, and mine are up front. Feel free to shoot me or Michelle topics on the seminar for next time. If there's anything that you'd like to hear, if you want to hear more about paid leave once this tax comes into effect, I'm sure there'll be more information coming out in the meantime, leading up to the next event. So feel free to shoot us those topics.
And I will be happy to facilitate any answers to questions that Kevin and Jason have, for you. And just a small commercial break for Think Local First DC, because it's a lot of new people, at least to me. So glad that you were able to participate today, and we would certainly love for you to join us. Membership levels start at $25 a year, so it's very affordable. And I don't know if Tom was able to say in his introduction, but Tom Martin is one of our board of director members, and we have another board member here today, Mari Rodella, who's our vice president, and she's also chief cultural officer at DC Brow. So you're very wonderful members at Think Local First DC, and we'd love for you to join us. Thank you.
Thank you.